Thomas is being very inconsistent because there are distinctions between Scalia's opinion and Alito's opinion, and Thomas is joining both.
Well, he's consistent that if it's against gays and lesbians,
yeah.
he's on that side.
I'll resist making a lot worse statements.
Yeah,
about
but so at any rate, what Chief Justice Roberts in his dissent and Justice Scalia in his dissent make very clear is that they are worried about the impact that Justice Kennedy's opinion might have on pending lawsuits for same-sex marriage in places like Hawaii and Nevada and New Jersey and Illinois, and now I think there may be a few others. New Mexico, there's a lawsuit. So they're concerned. So Justice Kennedy says we don't have to decide the question of whether same-sex couples can marry. That's not before us. That's a 14th Amendment question. We are concerned with the Fifth Amendment of the Bill of Rights, which is binding on the federal government, and whether that's violated by DOMA.
And explain what the Fifth Amendment says, because most people think of the Fifth Amendment, I don't have to testify against myself.
But among other things, it says that no person shall be deprived of life, liberty, or property without due process of law. And the Supreme Court has held in decisions going back now a century or more that there is a substantive component of that. Even though due process sounds like a procedural protection, there's a substantive component that means that the government has to have a legitimate reason for taking away your life, liberty, or your property.
And in the case of Edie Windsor, $363,000 extra in taxes.
But it's more liberty. The issue there, Justice Kennedy says that the right to have your state law marriage recognized by the federal government is an aspect of liberty protected by the Fifth Amendment.
And
in addition...
And this is interpreted as equal protection? Is that how we get to that?
In addition, the Supreme Court has said that the guarantee of due process would be pretty meaningless if it did not incorporate a requirement of equal treatment for similarly situated people. So the court has read into the Fifth Amendment an equal protection requirement that it says is exactly the same as the equal protection requirement under the 14th Amendment, which is binding on state governments.
Okay.
It's complicated.
Now,
this is why law students struggle through con law.
Now, Larry, he uses the phrase, in quotes, careful consideration standard. A careful I hadn't heard this before. We've heard of heightened scrutiny, strict scrutiny, all these kinds of things. What does the careful consideration standard mean?
Well, I don't think you're alone in having never heard of it. It's a new standard, I think, as of today.
It isn't. You know why?
Why not?
Because it's in quotes. He quotes from another case.
Okay, let me try another one.
And you know what case he quotes from? Romer versus Evans. He quotes himself where he used the same phrase, and he said, when a state enactment takes away rights from a specific group of people, we have to give careful consideration.
When you're disfavoring a group. But some have called this rational basis with a bite or rational basis plus.
Right.
He doesn't use those terms.
I like the dental term, rational basis with teeth.
With teeth, right. So there's this somewhat mysterious standard, and he does get maybe appropriately some criticism in the dissent, saying, what is this thing you're making up here, this new standard?
Well, but, why not make something up? And I assume this is somewhere between rational basis, which rational basis review means that if you can come up with any explanation that isn't from Mars, you can let a law stand.
Correct.
And the bigots, to use a legal term, would say that they have plenty of reasons that we should be kept out of marriage, and they've trotted them all out. And if the court agreed with them, that would be a rational basis review. Heightened scrutiny would require better reasons, and strict scrutiny would require really good reasons. And careful consideration is somewhere between rational basis and heightened scrutiny.
Or maybe another way to look at it is rational basis when it deals with treating people differently has an extra oomph, and there's this concern that he's articulated many times, Justice Kennedy, including today, which is that you just can't, if animus is all you got, that's not good enough.
All right.
Well, I think that's in fact an analysis that says we're not even going to, we are dismissing their reasons, but we don't even have to go too far with that as long as we can see that their real reason is hatred, is animus. And that is really not legitimate.
It doesn't even have to be hatred. I mean, the point that Kennedy makes, I mean, he mentions due process liberty, he mentions equal protection, he also mentions federalism. And he goes to develop the history of state dominion over the issue of marriage. That traditionally in the United States we have a division of authority between federal and state government. Certain things are considered quintessentially matters of state law, and one is marriage. We don't have federal marriage licenses in this country. Prior to DOMA, we never had a universal federal definition of marriage.
Right.
We had a definition of marriage in certain statutes. Marriage is defined in particular ways because of particular policy concerns of the statute as to who's married. But generally, the United States Code lacked a general definition of marriage until DOMA was passed. So he says, you know, our tradition is states decide who gets married, and the federal government respects those marriages unless there is a very, very good policy reason for not respecting certain marriages.
And a lot of people watching this show, and most people are going to want to know what rights same-sex legally married couples are going to have, or possibly still not have in some cases if they move around the country. But
Right.
before we leave the issue
But
of...
we still haven't gotten to Kennedy's rationale, because he had a
Right.
third rationale,
Yes.
and I want to bring this to his fruition, and that's
Please.
federalism. He says federalism is an issue here too, and according to Chief Justice Roberts in his dissent, the main theme of the majority opinion is federalism. And the reason he said that is to try to signal to lower courts that they shouldn't rely on this decision in pending lawsuits seeking same-sex marriage.
But I would think Roberts would
Because-
support federalism.
Well, he is in favor of federalism.
So what
Very
is,
much so.
not having read his dissent yet,
Yes.
or any of the others, what do the dissents say? What is their argument against the decision?
All right. Roberts and Scalia both say that the case shouldn't have been before the court.
Oh, it's
They
a
both-
standing question.
Well, it's not really standing. It's a jurisdictional question. They say when we had two formal parties to the case when it was filed, the United States of America was the defendant as represented by the Justice Department, and Edie Windsor was the plaintiff. The trial court was given a motion to dismiss by the federal government. The federal government's motion said, please don't dismiss this case, rule in favor of Ms. Windsor.
Yes.
You know, and Scalia says in his dissent, oh, that's bizarre. You know, so the case goes to the Second Circuit because the Justice